Good afternoon, sir, and all
Good
the
afternoon.
participants present here. I am Meet Kaur, volunteer of Sambhav Initiative and moderator for this event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Mr. Mehul Kothari, sir, and to all the participants in this 2 weeks online national capacity building program on art of contract drafting from fundamental to enforcement, organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, mental health, and creating legal literacy under the direction and guidance of Patron in Chief of Sambhav Initiative, Honorable Justice E.K. Thakkar, sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Justice M.R. Shah, sir, former Judge of Supreme Court of India, in collaboration with Pro Bono India, which is working towards legal aid and legal literacy. Where today's session is all about e-commerce and digital platform contract, including privacy policies. Before we start the session, please adhere to some webinar etiquettes. I request all the attendees to keep their microphones muted during the session. If you have any questions, please use the chat box or raise your hand. It is a privilege to have with us and honor to introduce Mr. Mehul Kothari, sir, Advocate, Rajasthan High Court. Sir holds a Bachelor of Laws from Jindal Global Law School, complemented by a Bachelor of Arts. Sir pursued his Master of Laws through the prestigious Erasmus Mundus program. With a specialization in competition law, this program afforded him the opportunity to study across three countries, that is, Israel, the Netherlands, and Austria. Sir is enrolled with the Bar Council of Rajasthan in 2017. Prior to joining Kothari and Associates, Sir gained valuable legal experience with the AZB and partners at Bangalore office. Sir is currently empaneled with several general insurance companies representing their interests before the Honorable Rajasthan High Court. We are deeply honored to have you with us today, sir. Over to you, sir.
Thank you, and good afternoon to everybody. I would really like to thank Sambhav Initiative to think of me to speak on this important topic of e-commerce and digital contracts. As all of us are moving towards the digital e-commerce platforms, and which is transforming, the legal relations also. When we talk about the formal contracts under the Indian Contract Act, Section 10 comes to our mind, and the comparison between the traditional and the digital contract formation is something which is coming to age with the instant commerce being preferred by everybody. So let's first talk about the e-commerce contracts in the sense of what it provides to the platforms who are hosting their services. It provides data, and today data is considered the next sort of net worth. So if we say there is around 328 million terabytes of data which is generated each day, and slowly but every all the brick mortar stores are being left behind by these e-commerce giants and e-commerce platforms. Indian courts in 2010, the first case where the Supreme Court upheld a contract concluded entirely through email, recognizing it as a binding agreement in absence of any formal written agreement. The court emphasized the intention to be bound and the presence of a concluded bargain, regardless of absence of any signed physical document. So that was the judgment passed in by the Supreme Court in the case of Trimax International versus Vedanta Aluminium in 2008. So the shift to digital commerce is also transforming the legal relations from deliberate signed agreements to automated and instant transactions. Platforms like Amazon, Zomato, Instagram now function as spaces where legal obligations are being created and enforced. This evolution is also bringing a significant change to contract law, which is it is bringing it closer to technology, speed, and standardization. The two statutes which sort of govern these relations are the Indian Contract Act and the Information Technology Act, which guide the interpretation of what consent should be and how these digital contract consent, which is obtained, would be enforced in this digital environment. So when we talk about e-commerce, what are the types of e-commerce which works in different three formats to say so? One is the business to business platforms, the other is a business to consumer platform, and the third is a consumer to consumer platform. In a business to, I'm so sorry for the disturbance, this traffic, so just bear with that. So business to business platforms is designed specifically to handle needs of businesses such as bulk orders or complex pricing structures which integrate with enterprise systems. Examples of these business to business platforms would be Alibaba or IndiaMart. Then business to consumer platforms are which facilitate transactions between consumers offering a wide range of goods and services, which we all very occasionally use sitting at our homes with the comfort of a click. We order things online on Amazon, Flipkart, Zomato, Uber, platforms like Blinkit, Grow, Chirodha, where every day we are sort of coming in interaction with e-commerce contracts. We are agreeing to those policies, sometimes with our implied consent, sometimes with an express consent, which we will obviously cover when we go further into the topic. Then the third kind of a platform is consumer to consumer platform, where it's an online marketplace where individuals will buy and sell goods or services directly to each other. These examples of these sort of platforms would be eBay, OLX, Airbnb. Uh, so the Indian Contract Act and the validity of digital agreements is something which is very important to be understood and emphasized on, because the Indian Contract Act remains the foundational statute which governs the formation, the enforceability, and the validity of any contract, irrespective of the mode of execution, be it online or physical. As per Section 10 of the Indian Contract Act, which states that all agreements or contracts, if they are made by free consent of parties competent to contract for a lawful consideration and a lawful object. So these are the key ingredients for any sort of a valid contract. And Section 10A of the IT Act, it states, I'll just read the key ingredients once and then we can further go on to the topic. Where in a contract formation, the communication of proposals, the acceptance of proposals, and the revocation of proposals and acceptance, as the case may be, are expressed in an electronic form or by means of an electronic record. Such contract shall not be deemed to be enforceable solely on the ground that such electronic form or means was used for that purpose. And Indian courts have time and again upheld the enforcement of such digital contracts where the requirements of the Section 10 requirements of the Contract Act are met. The electronic express consent is sufficient in the eyes of the law, and provided it is not vitiated by the key ingredients that the Contract Act states, which is fraud, coercion, or misrepresentation. So, under the IT Act, what would form the essence or the key ingredient is digital consent, because everybody is moving towards e-commerce. Digital consent before accessing any of these platforms becomes key for the contract to be enforceable. And under the IT Act, therefore, Section 4, which equates electronic records with physical documents, where any information required by law to be in writing, the requirement is satisfied if the information is made available in the electronic form and is accessible for subsequent reference. The IT Act operates in cohorts with the Indian Contract Act, validating digital expressions of consent, such as clicking the agreement buttons that we so often do while we are using computers or our phone, or replying via electronic communication, or engaging in transactions on online platforms. So, what are these sort of agreements that come under the ambit of e-commerce contracts? One of them that comes to my mind is click wrap agreements. What do we mean by when we say click wrap agreements? These are type of online contracts where a user, that is us or any person who's using the software, indicates their consent to the terms and conditions by clicking a button on, say, which says I agree or accept, or checking a box signifying their agreement before proceeding with the transaction or service. Example of such click wrap agreements are software licenses, which we so often use, and social media platforms that we use. The second type of agreement is a browse wrap agreements, which is a type of an online contract where users are deemed to have accepted the terms and conditions of a website or digital service simply by using or accessing it. So sometimes these browse wrap agreements, there is not express consent which is taken. It is implied consent when you are going onto a browsing website and you browse the content. The act of doing so is consented in itself. Then some of the things which are essential when we use any sort of e-commerce platform are terms of use and so service agreements, which is a relationship between the user and the platform, which define your conduct and allocates responsibility and establishes the dispute resolution process once you go onto that platform. So some of the issues that come in this sort of a terms of use document that you see on online platforms is that these agreements are unilaterally drafted and they are always presented to you through a hyperlink or a prompt which pops up on your window, and they are typically non-negotiable. In a physical contract, there is always negotiation, as you will hear throughout these 15 days, that any contract essence is always there is negotiation between two parties. But in e-commerce platforms, these terms of use which are shown to you on the platform, wherever you're using that platform, those clauses or those terms are generally non-negotiable. But the courts still recognize them as valid, where users have the opportunity to scroll through the terms and through express or implied consent proceed ahead. Once you proceed ahead, you've sort of given a go by and you say yes, I agree to it, and you proceed onto the platform. So the enforceability of these contracts then would depend on the visibility of such terms, the accessibility of such terms, and the fairness of such terms, which is drafted by the e-commerce platforms. These terms sometimes they waive off essential rights. So these things then have to be then seen in the eyes of law, and sort of balanced off with public policy and contractual fairness. And beyond these transactions, these agreements, that the terms of use and service agreements that are shown on platforms, enable platforms to regulate user behavior, and they administer internal enforcement. So consent remains formal, but largely non-negotiable, because no e-commerce platform would, provide you the option of saying, no, I don't agree to this aspect, but I agree to this aspect. So the consent, you have to agree to it. If you want to use the platform, you agree to it, and then it sort of becomes non-negotiable. So under the sale of goods, because e-commerce platforms in generally in a formal physical contract, when there are aspects of Indian Contract Act, there are aspects of sales of goods. So under a Sales of Goods Act, a contract of sale would involve a transfer of ownership for a price, which is also the case in e-commerce between an identifiable parties and defined delivery terms, which is also the case in a physical contract and also the case in e-commerce. But in e-commerce, the sales of goods, the structure is very fragmented, because a purchase may involve a platform, an external seller who's selling on that platform, and a third party logistical provider who brings that good to you, to the buyer. So in these, the buyer has to accept all the terms, those of the platform, of the vendor who's selling, and the delivery service who's bringing that good to you. So the contracts are formed through sequential digital consents. You have to at every step agree to it. Only then will you proceed ahead to the last page, which is the payment gateway. So the buyer often does not engage directly with the seller or with the logistical provider. It is the e-commerce platforms who is signing all these contracts, which are not even visible to you. So Indian law continues to apply on these transactions, but it raises issues regarding the allocation of risk and remedies of non-performance. So again, as I said, that payment gateway agreements, that is something that's not visible to us as a buyer on e-commerce platforms. But digital payment triggers interactions between the user, the platform, and the merchant payment gateway and the banking institutions. These Again, these relations are governed by distinct agreements, often unknown to the user. The gateway contract with the vendor or the platform is set up by a separate agreement, which is generally called the merchant service agreements, which governs the transactions, the chargeback, the data retention, and the compliance, obviously, with the Reserve Bank of India guidelines, and the settlement timelines within which the payment needs to travel from the payment gateway to the seller. So these terms are not these terms are binding, obviously, but are not disclosed to the end users who are using the platform to purchase something. So user consent to payment is being treated as consent to all the underlying legal arrangements that are part of that payment gateway aspect. Payment is obviously not merely procedural. It is the legal act that completes the sale and activates the intermediary's obligations, which is the e-commerce platform's obligations, and invokes the statutory protection. So consent must be supported in all digital contracts by clarity and access and procedural safeguards that the e-commerce platform would generally have. Uh, the other sort of contracts that are part of this system are gig economy and digital labor contracts. So often we see that there are so many platforms which are offering digital contracts which fall outside the conventional employment labor laws. So workers such as drivers of Uber, Ola, delivery agents of Blinkit, Zepto, and these are freelancers, right? Like in the sense, a labor in a gig economy, a labor market is characterized by short-term contract of freelance work for a short-term job, such as ride sharing, as I said, Uber, Ola, and food package delivery. Terms in these often include exclusivity, variable pay. There is always an algorithmic task allocation and unilateral suspension of rights, which is all the right always with the e-commerce platform. Despite this, workers remain economically dependent on these platforms. Indian law is currently lacking a statutory framework for such platform labor, and existing labor codes apply only to defined categories like employees or workmen. So once we talk about contractual autonomy and structure, the essence of a physical contract is the autonomy that a person enjoys while entering into a physical contract. And what is the distinguishment between a physical contract and the autonomy a person enjoys and a digital choice? So contract law, as I said, is founded on autonomy, legal obligation, which always arises from voluntary and informed consent. In digital settings, the consent is captured through a lot of interfaces and not negotiation. You click on next and you go on to the next page and so on and so forth. But users accept these standardized terms through sequence and not deliberation of mind. So choice in e-commerce platform is always limited. If you go on any platform and you intend to buy that thing, you have to accept what the terms of that e-commerce platform are. Otherwise, you will not be able to purchase that item. This structure sometimes does not invalidate contracts, but raises concerns of substance over form. Consent may be formal, yet shaped by design, literacy, access, and necessity. Under Section 14 of the Indian Contract Act, free consent remains essential. In digital contracting, its validity depends not only on expression, but on the conditions of its formation. So there is a lot of, at least it's my opinion and my belief that there is a lot of inequality of bargaining power in a digital contract compared to a physical contract. Indian contract law recognizes that contractual freedom is limited where dominant parties always impose the terms. And therefore, Supreme Court in a judgment of 1986 held that standard firm contracts may be set aside for unconscionability and public policy issues. So digital platforms occupy a dominant position in this day and age. So their terms are generally drafted very unilaterally, keeping in mind only their perspective, revised without consultation, and accepted through automated flows. So users cannot modify these clauses without losing access to that platform. So let's take up one example and a case study of how Amazon and the structure of Amazon works through its multilateral digital contracts. So Amazon creates, it's a case study that I came across while working on this topic, that Amazon creates a layered digital contract through non-negotiable terms, which is embedded through its each transaction process. A consumer's consent is extended beyond purchase to include the platform's term of use, its seller's conditions, and policies on payments, logistics, return policies, and refund policies, and its dispute resolution mechanisms. Consent is often inferred through continued use and automated checkout flows. For third party sellers who are on Amazon, it enforces a service business solutions agreement, which covers all aspects of listing, pricing, logistics, fee, and liability. This agreement is subject to a unilateral modification and with continued use treated as assent. So Amazon is an intermediary. It acts as an intermediary also, policymaker, while it drafts its contract terms of use conditions, and as adjudicator to solve dispute with customers. It's an A to it's to is to say so. It has an A to Z guarantee, and it provides its own internal dispute resolution. So contractual obligations arises through system designs and defaults rather than negotiation, which is key aspect of Indian Contract Act. The legal concern is in such a case that whether such consents reflects knowledge, voluntariness, and fairness, because the negotiation aspect is never the user is never involved in the negotiation when he's using any such e-commerce platform. Uh, So let's talk about the consent and data collection and then flow and then go on to talking about the privacy policy aspect. So recently in 2023, the Indian Parliament drafted an enactment called the Digital Personal Data Protection Act, which specifies and states that consent must be free, specified, informed, and unambiguous, given through clear affirmative action. So, a lot of the times when you go on e-platforms, you see a pop-up come up which says that the site is going to do so and so. It is going to access the data. It's going to use that data for its commercialized used, and you have to agree to it before you can access the website. So this sort of enforcement has started to happen more and more after this act has come. And also it was happening before. And there are, in different countries, there are different enactments. In the European Union, there is a GDPR, General Data Protection Right, which has massive implications and penalties and liabilities if not adhered to. And similarly in India, it's the Digital Personal Data Protection Act. A notice stating, so in this act there has to be a notice stating the purpose of data collection, which must precede consent. A consent cannot be bundled with, inferred from silence or condition on or unrelated terms. The users must retain the right to withdraw consent at any time. So this act, after its enactment, has shifted the burden to the data fiduciary to demonstrate lawful consent. Processing beyond consent attracts liability under this act. This act is obviously enacted, but it awaits the operational rules still. So it's a work in the progress, but it is something which is to protect your privacy. And therefore, once we use any of these platforms as YouTube, Amazon, Instagram, there is this sort of prompt that comes to you that these websites would be collecting your data. So let's talk a little bit about what a privacy policy in contract should be, what the elements of the same should be. So the rule of thumb for any e-commerce platform and the aspects that it needs to keep in mind with regard to privacy policy is that it needs to inform any person which is accessing the site about the data it collects and manages. It needs to give that particular person who's accessing the e-commerce platform a choice to opt in and opt out from getting that data collected. And it also needs to give the person access to the information that platform collects and the third parties collect while using that platform. So, so one more aspect in e-commerce platform is about consumer sovereignty, the choice of the consumer, and the fairness the e-commerce platforms need to have in their contracts while accessing these websites. The contract law always presumes that voluntary consent needs to be between equals. In digital commerce, the concept is a little tweaked because this presumption weakens because you have to give your consent, but it can sometimes be voluntary, it can sometimes be involuntary. If you have to process, if you have to access that e-commerce platform, the consent has the aspect of giving consent and your right to say yes or no weakens. Users are required to always accept the platform drafted terms, as we've discussed, as a precondition to accessing that website. These contracts are standardized and always non-negotiable, and often includes clauses which limit their liability or restrict jurisdiction or authorize unilateral modification to the e-commerce platform. So what appears as consent is frequently a procedural formality, to say so. Indian courts have always recognized the limits of the contractual autonomy in such settings. The doctrine of unequal bargaining power applied in consumer cases questions the legitimacy of such terms under the which are the e-commerce platform offers. So the Consumer Protection Act of 2019 prohibits such unfair terms that cause such significant imbalance to the consumer's detriment. So when we talk about restructuring the sort of contractual doctrine for the digital age, because the Indian Contract Act was drafted back in 1872, and a lot of the things have changed since then, obviously. So digital commerce requires a re-examination of the classical contractual principles. The consent is to be restructured, agency is dispersed, and the legal responsibility is distributed across platform systems. The digital contracts appear in multiple forms, including the click wrap, browse agreements, and smart contracts. Their validity not only depends on signature, but on visibility, structure, and fairness of consent. So the traditional doctrine remains relevant, but are mediated by design, automation, and standardization. The legal focus has shifted from negotiation to architecture of the e-commerce platform. Platforms concentrate on legal and economic powers. Laws such as the Consumer Protection Act and the Digital Personal Data Protection Act offer protection, but enforcement is limited, especially in these transactional contexts, because there's so many elements involved in e-commerce that to regulate it is going to be a tough task. The future doctrines must prioritize accessibility, procedural equity, and legitimate expectations. As platforms function as, to say so, quasi-public spaces, their responsibilities must reflect constitutional principles of consent, fairness. Yeah, thank you. I hope I have some drafts that I was requested by Jayant to share on privacy policies. I will do so with Jayant so it can be shared in the groups for everybody. And thank you. I hope I am tried to cover some of the aspects that e-commerce contracts have. Yeah, thank you.
Thank you, sir. Whosoever have any questions, you can ask your question in the chat box or can raise your hand.
Hello. Good afternoon, sir. So thank you for
Yes,
the
Sumit.
insightful session. And my question is, sir, now the IT Act has come, right? And
Yes.
many of the, for example, many of the employer-employee contract are
Yes.
happened on the mail, right? Earlier, they
Sorry, I lost you. I lost you in the middle. The Employment Act?
are mostly happened through the mail.
Yeah.
Like when we joined the company, they sent a mail, we accept the
Yes.
agreement. Or this
Yes.
all happened through the mail. But in the earlier approach, that all happened through the notarized document, where
Yes.
employee has to physically sign the document, right?
Yes.
So now, what is the validity of the this email contract? It is
Email.
still
So Sumit, yeah, is there a follow up or that's the question?
that's a question. Yeah.
Okay. So as I said, the courts have started to recognize these documents because from COVID, one thing that has come out is that work from home is something which is being offered across the country, and some people are working in India, working for firms outside. So these contracts that are signed digitally. So the IT Act recognizes these records, right? Section 10A and Section 4 of the IT Act very well recognizes these electronic forms of records. So once you say you are in employment, your employment has come to you by email. You have signed and sent it back. They have signed and kept it in their records. It's a valid document. It is enforceable. So the liabilities and terms and conditions therein would definitely be enforceable against you. It is a valid document to say so.
Okay. So there's a follow-up question. So it
Yeah.
is like a digitally signed, or we can scan our signature or then send it to.
You can scan it also. You can scan it and do it. The digital signature is an instrument which is validly recognized by the Information Technology Act of 2000. That is what I'm intent to say. If you see uh, Section 4, yeah, legal recognition of electronic records. So under this aspect, the judgment of 2010 of Supreme Court Trimax International versus Vedanta Aluminium, it talks about these aspects and it recognizes these aspects as valid instruments.
But the
The-
scan signature is also valid.
Yes, it is.
But one of the party can manipulate in the future that it is not our sign and someone other use my.
Look, that is always up for debate. That is always up for debate. One can always say or rebuke or say rebut and say this is not my signature. But then there are processes and procedure in law which can always disprove that claim of yours that this is not my signature. There is something called as forensic FSL, which is always done in cases of specific performance for property related disputes. That once a party says that this is not my signature, then the courts have a right to send that document to for FSL, forensic scientific report, and then their handwriting experts who study the document, and then they say whether it is your signature or not your signature. So there are always procedures in law which sort of balance on both sides. So if you raise that doubt, कि it's not my signature, it's not so easy to say it's not your signature.
Thank you
Hello.
very much, sir.
No problem. Thank
Hello,
you.
sir. Hello, sir.
Yes,
In
please.
the same line, I have a question. If I
Yes.
have sent a document for digital consent, and the party has signed a digital signature, not a scan and handwritten signature, then what level of signature shall we accept? Means there are levels, no, that Microsoft and
If you're
Apple.
talking from a perspective of an employer, sir, I would say digital
हाँ,
signature. Digital signature की जो key आती है सबके पास
हाँ,
जो आजकल
हाँ,
generally use हो रहे हैं,
हाँ,
even
yes,
government offices are using it.
हाँ, yes,
That
हाँ,
that is what I would
Adobe,
suggest that anybody should use.
हाँ, Adobe and Microsoft, they are giving the digital signatures, no.
Yeah,
So,
not only Microsoft, sir. I would
हाँ,
say in
हाँ,
today's day and age, there are so many secretariats in the central and the state governments who
हाँ,
are enforcing this digital signature as a valid form of attestation to a document.
okay, okay, thank you, sir.
Okay, there are some questions in the chat box. So generally, how many parties are involved in e-contract?
So again, like I said, it is a transactional nature, right? If you are a user on an e-commerce platform, you are contracting to that platform. But that e-commerce platform would have contracted so many other vendors like payment gateway merchants, logistical merchants, sellers who are selling on that platform. So there are many transactions which are there.
Okay. Next, who bears the responsibility in cases where there is a breach in online buying, like Amazon?
So in a case of Amazon, Amazon has a very robust dispute mechanism. You have obviously a return refund policy. You also have a policy of contacting the seller, informing him of the breach or the defect in his product, and then you have a customer service platform where you can always raise your grievance. But all of them come with their own stipulations, in the sense that some products only have a 7-day return, some products do not have a return policy. So before you go to add to cart and go to buy and make the payment, always read these terms and conditions. And therefore, again, I say that these e-commerce platforms and the terms and conditions that they are written, they're non-negotiable, right? If you intend to buy from any of these platforms, you do not have a chance to negotiate. Ki, bhai, this should not apply to me. This should apply to me. So be careful of what you are buying, from which platform you're buying. There are a lot of cases of frauds also now, with e-frauds which are coming. So there are so many aspects. So you have to be very careful. The aspect that all of us miss, even I do sometimes, that we don't even realize the kind of data that we are giving access to. So say you use any of these e-commerce platforms, which is Tata Click, Amazon, and you search for something and you do not end up buying it. The constant prompts that your phone keeps showing of that same product again and again. So psychologically, it creates such an effect on your mind, right? That I've looked for a watch. I wanted to buy a watch. I'm not going to buy that watch, and then continuously my phone keeps prompting me the same image of the watch. So the data, and this is what they're monetizing on, huh? Because these platforms, they are intermediaries, so they're not as such getting any money from offering this service. What they're getting money is from the aspect that the data you give, your address, your phone, your location, and we don't even know where this data is going after they're collecting it. Certain statutes are there, but we've not looked at it in detail as to what the effect of this is.
Yes, yes.
Yes.
And recently, some of the judgment in High Court, like, IP related, they asked to stop, selling counterfeited goods. They keep, listing on Amazon and Flipkart. So that's why this thing also, again, uh,
Absolutely.
things are
Absolutely.
there,
Yes, yes.
definitely.
There's so
We
many
also,
times that we hear cases that a person has ordered a phone, and once the phone is delivered, there is no phone inside. It's a piece of a stone or something. So it is worrying. And with the pace we are moving on to this e-commerce, it is bound to happen that there will be many more such cases in the future.
Uh, Thank you so much, sir.
Thank
Uh,
you, Amneet. Thank you.
And on behalf of the organizing committee, I would like to extend our sincere gratitude to you, sir, for delivering such a thoughtful and enriching session today. We are truly thankful to you, sir, not only for accepting our invitation, but also for taking time to guide and inspire all the participants. Thank
I'm
you, sir.
I'm grateful for you to have me. Thank you
thank
guys.
you,
It was nice meeting all of you. Take care.
thank you, thank you. Thank you, Avneet, and thank you, participant, for joining. See you tomorrow.